Welcome back, viewers. Before the break, we were talking about building accidents and in particular the case of Ianello. Tony.
John, we're just going to go into the respective liabilities of the three defendants, which was the employer, the architect and the council. Now, the first thing is, what was the employer's obligations for his employee? The son, as with the father.
The employer, Tony, is required to provide a safe workplace for its employee.
And the law says they've got a non-delegable duty of care, which means they just can't delegate that duty to a third party.
Exactly. It was found here that there was no system of work and no safe system of work put in place for the employee to conduct his duties.
So they needed to develop a system of installing air conditioning units whereby it was safe for the workers to go up and down the roof.
Exactly.
Without the risks of going through skylights.
Exactly.
Now, there was no risk assessment done in this case.
No. And as we know, the three defendants, Tony, actually admitted liability here in this case. They admitted that they've done the wrong thing. The judge now had to determine the proportionate liability between the three defendants. And for the employer, the judge found that they were 25% liable for the injuries to the worker.
Nuncio, in this one here, the judge also said that if the employer had done a risk assessment and the council wasn't prepared, that is the occupier wasn't prepared to do anything to rectify the problems of accessing the roof, he should have not allowed his workers on the site.
Exactly right. Even though it hadn't been performed, you still got a responsibility to your employees, and you have to make those decisions as they see fit.
And assuming he made the complaint to the council, and the council said, no, we're not doing anything, what's next? What do? You complain to WorkSafe?
Well, you can, of course.
But again, or as you said, Tony, don't put your employees on site. You refuse them to work.
And what about the fact, okay, here it was father and son, but the average employee is not employed by the son. So most people would be too scared not to work. They'd be scared, they'd fear for their job, wouldn't they?
Well, they will, but at the same time, the occupier here, they had a massive liability, didn't they, Tony?
Yeah, but what I'm saying is the employer, if you go up to your employer and say, listen, it's not safe, I'm going to walk off the site. If it's one individual, isn't he at risk of losing his job?
He is. However, these usually are union sites, Tony. So you've usually got
Speak to the union, you've got that coverage.
You've got that backing, and also, look, if you have to get in touch with WorkCover, get in touch with WorkCover. Otherwise, if you just do nothing, well, something as serious as this could occur.
I guess because you've got a union on site here, get the union rep involved. And that way, if there's anything whereby they don't want to comply, there can be a walk-off, stop work meeting, which they usually do.
Exactly.
Nuncio, tell us about the responsibility of the council in this case.
Well, the council took the lion's share of the responsibility, 65% in fact, and it was found that obviously they were liable as occupiers of the Performing Arts Centre. They knew that contractors were going to be on site, maintaining, installing the air conditioning units, and they did nothing to assist those workers up there. There was, as Tony said before, no handrails, no walkways, and also no mesh over the skylight. And as the,
just on the issue of the mesh, there was a fellow that was employed to look after occupational health and safety with no qualifications, is that correct?
Exactly right.
And he also got a quote for the skylights to get the mesh.
Yeah, and that quote was only just under $3,000, so that's all it would have taken to prevent this case or this injury from occurring. So, and that's why WorkSafe actually issued an improvement notice after that.
Did he put the quote to the council? But apparently he wasn't obliged to do it. Anything under $5,000, he had authority to go ahead and get the job done.
Yeah. They were aware of what needed to be done. They didn't do nothing about it. So that's why they've taken, again, Tony, the lion's share of it. And the other 10% is out of the architect. And they were found the fact that they were responsible for, I suppose, doing the drawings and the design of the building, they should have foreseen that.
Before we get to the architect, can I just ask John this? John, is it surprising that after Mr. Ianello fell through the roof and nearly died, they've gone ahead and spent the $3,000, whatever it was, or just under $3,000, to put the mesh in so that he couldn't have fallen through the skylight in the first place?
It's too late, Tony. It's too late.
And isn't that one of the major reasons why they admitted liability?
Well, they themselves admitted that they've done wrong. They've tried to rectify the problem, but it was too late.
That's it. Now, the third person that was responsible was the architect.
Yep.
What did he do wrong, John?
Well, this is unusual, Tony. The architect, I have to admit, I don't really see it that often, but
Okay.
it looks like he hasn't drawn the drawings properly to recognise the fact that this type of injury could occur. Now,
John, many years earlier, the place was refurbished. It was just redone. He didn't even turn his mind to the risk of people going on the roof.
So
there's going to be maintenance on the roof. There's going to be air conditioning units. There'll obviously be maintenance of the roof itself.
So we've got issues of foreseeability here, Tony.
No, it's foreseeable. It's foreseeable. You're going to have people on the roof and they're going to be up there doing all sorts of things, and you could be tripping on these clip lock, as the judge described it, and also there was nothing to prevent people falling through skylights.
It was a new building, and the architects are trained in what they do, and they should have foreseen it. So I think some liability falls on them.
Okay, the court gave the plaintiff $420,000, which was broken up 65 for council, 25 the employee, and 10% the architect.
Exactly right.
Let's quickly get on to another case of Simons and Haggerty. Nuncio, can you briefly tell us what the facts were? This
is a case in which the plaintiff was a roofing plumber and had to transport 20 sheets of corrugated metal to about 30-40 metres away, and they were instructed by the foreman to use the scissor lift that was on site. And in doing so, that wasn't attached to the handrail. There was, they were loose, these corrugated sheets. In moving them, they almost fell. He put his body underneath it to hold them up. As a result, suffered serious injury to his back, and that's where this case stems from.
Not so he put his body underneath to prevent him from falling because the other worker would have been injured, apparently. That's the facts.
I believe so, yes.
Yeah. Now, John, liability?
So we've got an employer that has not provided, again, a safe workplace, but not only that, a safe mechanism to perform the duties.
Well, in their defence, they pleaded that this guy wasn't supposed to be using scissor lifts, and yet when the evidence came out, they didn't put up anyone to say, present an alternative system of work.
There was no alternative, and also he was actually directed to use this, wasn't he, Tony?
Well, there was no cranes, there was no equipment, so the court found in his favour.
Exactly.
The thing in this case, Nuncio, was that his damages were heavily discounted. For what reason?
He's a litigious plaintiff, and he had a previous knee injury and also had a heart condition. And the court found that because of his heart condition, he probably would not work to 65 as hoped or aspired to, and as such, they only gave him 3 years of loss of earnings, Tony.
In fact, John, in this case here, the court went so far as to say there's evidence that he'll be lucky to survive another 10 years because of his heart.
He still received $326 grand.
He did. He got $326,000.
It's a substantial settlement.
It is.
Award there, Tony. Yeah.
Look, it's moved very, very quick, this segment. Look, Nuncio, thanks for coming on board.
Thanks, guys.
Viewers, don't go away. We'll be back with Kathy's mailbag just after the break. Thank you.